In today's video, we're going to discuss how to contest a will. We'll also discuss some of the key legal reasons to challenge a will and how the caveat process works. My name is ERIK BROEL, and I'm the founder and CEO of Georgia Probate Law Group. At our firm, we help families who have lost a loved one navigate the complex and confusing legal process so they can make sure the estate is handled properly and their loved one's memory is honored. Our team has helped hundreds of families with will contests. Now, everything discussed in this video is for general information and is not legal advice. For specific information about your situation, please contact our office and set up a consultation. If you'd like more information about Georgia probate topics, click the link in the description below or go to our website, www.georgiaprobatelaw.com. While there, be sure to download our Georgia Probate Handbook so you know how the estate is supposed to be handled. For our topic today, how does a will contest actually work? Well, first, when you file a legal objection to a will, we call that a caveat. Now, the caveat must identify all the legal objections to the validity of a will. Remember, in a caveat, you're asking the court to overturn the will in its entirety. There's typically not much middle ground to modify the will. So the caveat must tell the court the legal reasons why the will should be declared invalid. What are some common legal objections to a will? Well, number one, there was an absence of the formalities necessary when the will was signed. Number two, the person who signed the will lacked capacity, what we call testamentary capacity. Number three, there was fraud in signing the will. Number four, someone exerted undue influence over the person who made the will. Number five, there was a mistake when the will was filed. Number six, there was a forgery on the signatures of the will. And number seven, the will was later revoked. Now, there are other legal grounds for caveat, of course, but hopefully these seven give you an idea of some of the most common ones. Also, each of these grounds for objection have several factors that must be proven in order to win on that objection. As you can imagine, it gets complicated very quickly. How does filing a will contest case actually work? Well, filing the caveat kicks off a legal dispute in probate court, and that dispute has several stages. First, when drafting the caveat, it is important to make sure you identify all of the legal grounds that apply. If you leave one out, you risk losing it unless the caveat is later amended. When the caveat is filed, it is okay to simply state objections even if you do not yet have the evidence to support them. After the caveat is filed, the case will enter a phase called discovery, where each side has the opportunity to gather evidence to prove their case. During discovery and after discovery, it is common for motions to be filed by either side asking the court to take an action, such as excluding evidence or granting a summary judgment. It's also very common for mediation to be required at some point during the case. Sometime after discovery ends, the case will be scheduled for a trial where each party will present their case and their evidence, and the court will make a determination about whether the will is valid or invalid. As a result, it is vitally important that evidence be gathered to support the allegations made in the caveat. Without evidence, it is very unlikely that the will contest will be successful. This is a complex situation, and I do not recommend that you try to handle a will contest without a qualified probate attorney on your side. In another video, we're going to discuss some of the most common will contest scenarios, so be on the lookout for that. As always, thank you for watching.